The prosecutors believe the court is creating error in the Bryan Kohberger matter. This is why you want a body for a homicide trial. Another serial killer and another guy in a position of authority arrested for you know what. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can listen to us anytime on any of your favorite podcasting apps. All right, quick reminder. Tonight, we have our Tuesday night live program right here, 6 p.m. Mountain Time. Please join us. We have a lot of stories to talk about. Not only what we're going to talk about today, but anything else you want to talk about. Probably talk about that, serial killer there in Long Island as well. So please join us tonight, 6 p.m. Mountain Time. And then if you're a Patreon member, that's right, we'll do our Patreon show immediately following that. All right, let's go ahead and open the record for July 18th, 2023. And our first story, that's right, the prosecutors in the Bryan Kohberger matter, well, they think the judge is creating error and they want him to fix it. What do I mean? What am I talking about? Well, as you may recall, back on July 10th, the court issued an order based upon the defense's motion to stay the proceedings. The defense wanted to challenge the indictment of itself, but they hadn't received any of the documents necessary to do that. The transcripts weren't done. The court said, hey, I get it. You have a right to challenge the grand jury proceedings, but you haven't given me anything where I can actually issue the stay that's supposed to go into place when that takes place because you haven't been given the transcripts to do anything. So the judge said it's premature, but I'm going to toll speedy trial, which means stop the clicking of the speedy trial clock for 37 days. Well, now the prosecutors say, hey, judge, you can't do that, and you're creating potential error. So, like I said, the prosecution requests that the court reconsider their order staying speedy trial in the Bryan Kohberger matter, and they allege that the law does not allow the defendant to partially waive his statutory right to speedy trial, and thus his acquiescence to the limited stay should be deemed to be a full waiver of speedy trial. Now, this obviously creates a bunch of litigation in the future if the court doesn't get this right. As you recall, in Idaho, the defendant has 6 months from the date that he says not guilty for his trial to take place. If they get him to trial within 6 months and a day, the case gets dismissed. So, if the court doesn't have the authority to waive speedy trial, or the defendant doesn't unequivocally waive speedy trial on the record, and the court is operating under we got at least another 37 days, don't worry about it, and he doesn't, guess what? Bryan Kohberger could walk free. Now, I don't think the court's going to let that happen, but that is one of the draconian consequences that, in fact, could take place. So the prosecutors go on and they note that the court's stay has no practical effect where the parties are continuing to litigate discovery matters and file motions. And there's a trial setting. And the defendant is free to request a stay in the future due to these practical considerations. And the state says that the court needs to rescind the order staying that time for speedy trial. Now, the state further requests that the jury trial in this matter remain set for October 2nd of 2023, or alternatively, that it be moved beyond the speedy trial period only if the defendant unambiguously waives his right to a speedy trial. And the state makes this request to give to the parties in this matter, the victim's family, as well as witnesses, some predictability as to future trial dates. And not only that, most importantly, to protect the record and to avoid needless speedy trial litigation down the road. It's an actual issue. You see, ladies and gentlemen, where everybody thought this was going to be a slam dunk case, the defense made a simple request. The judge made a decision, and suddenly it's all a big mess. And if there is a conviction down the road, guess what? Speedy trial. Do you remember when this happened before? Oh, yeah, that's right. Lori Vallow. Remember that. I told you, that's the issue on appeal, speedy trial. So the prosecution went on in their motion to remind the judge that obviously Kohberger is charged with 4 counts of first-degree murder and burglary, and that took place on May 16th. And on May 19th, the defendant filed motions requesting the grand jury materials, including the record and all the transcript. In the days that followed, the state and the defense conferred, but were unable to reach an agreement as to the scope of the grand jury materials subject to release under the Idaho criminal rules. Then, on June 13th, the defendant filed a motion to stay proceedings, arguing that he intends to contest the indictment. Well, that's great if you intend to, but you actually have to be able to make a showing at the time that you make their request. So the court, they asked the court then to stay this case so that they could discover the grounds upon which to do so. Basically, their motion wasn't ripe yet, but they had to make these arguments early on. But the prosecution also has the obligation to get all this information to the defense in a timely manner so that they can meet these statutory deadlines. So the sole legal basis offered by the defendant in his request was the Idaho Code Section 2-213, which allows a party to request a stay in proceedings where there has been a substantial failure to comply with the applicable law in selecting the grand jury. Then on July 10th, the court issued an order for a limited stay of proceedings, and the court rejected the defendant's rationale that the Idaho Code that they cited to applies at this stage of the proceedings. Nevertheless, the court elected to issue the limited stay to toll speedy trial for 37 days, relying upon the good cause language found in Idaho Code Section 19-3501. And as the court noted in its order for limited stay of proceedings, Kohberger and his counsel agreed to the terms of this stay on July 6, 2023, acknowledging that he could not later argue that his right to speedy trial was violated so long as he is brought to trial within 6 months during the speedy trial period, plus the additional time that was stayed, 37 days. Trial is set to begin October 2nd, which means shouldn't be an issue as of yet. It's on the record. Well, the prosecutor then cites some Supreme Court Idaho State case law that says the court unambiguously rejected the notion that the defendant can partially but not fully waive his right to a speedy trial, explaining that the section at issue does not allow for such a limited waiver. Once the trial has been postponed, the 6-month statutory period no longer applies. In this case, the prosecution argues that the court issued its order for the stay after the defendant requested the stay under Idaho Code Section 2-213, which, as the court noted in its order, staying the time period for speedy trial is a premature request. And instead of issuing a stay under Idaho Code Section 2-213, the court crafted limited stay that served not to halt the proceedings in the traditional sense of stay, but rather to simply extend the period of speedy trial by some 37 days. The prosecution notes that the court left the trial date of October 2nd of 2023. Even though the defendant stated on the record that he didn't intend to waive his speedy trial right, the practical effect of his motion to stay and the court's subsequent order is that the court has issued an order upon the defendant's application the trial may be set outside of his 6-month speedy trial period. And it further complicates matters that the defendant has even stipulated to good cause under the very statute that the Idaho Supreme Court has held cannot allow for a limited speedy trial waiver. Whew. So what does that really mean? Okay, let's explain it. Like I said, the court granted a stay of 37 days. The trial date remains the same. So Bryan Kohberger will get to trial by October 2nd, unless, of course, he unequivocally waives his right to speedy trial. The prosecution saying, hey, judge, we want you to go back and tell Kohberger you either waive speedy trial unequivocally without any pressure or undue influence so that you can address these issues. If not, we're going to have this trial on October 2nd. If the defense attorneys need more time, they need to waive the speedy trial. And then who knows when this case could be set out into. Now, the prosecution here, though, are they making more issues than they really need to? I think they probably are, but they're trying to protect the record because speedy trial, it doesn't happen very often. But I'm telling you, I think that's going to be the issue in the Lori Vallow trial, is the whole speedy trial mess that the judge created by setting her trial outside of the time period required. Although the judge hasn't done that here, he's given a little bit of a buffer. But once again, if the trial takes place on October 2nd, no issue. The prosecution they want more time. Let's face it. The prosecution wants more time to prepare their case, and they want a date certain. The defense is having their cake and eat it too, which is, hey, we need more time, but we don't want to, really need more time. So we're going to try to jam the prosecution by keeping this trial date, which will be tough for them to do. But that's probably the best shot that they have. But in all reality, let's face it, it's a death penalty case. The defense is not going to be ready. So if I was the judge, I'd bring him in and say, let's just clean up the record. Defense, you want a continuance or you want to go to trial? And if you don't want your continuance now, I'm probably not going to be inclined to give it to you on, October 1st, the day before trial. So think wisely what you want to do. Problem solved. Now we just need the court to watch Crime Talk. Next on the docket, this is why you need a body when you do a homicide case. So an Arizona man accused of killing his 17-year-old stepdaughter by the name of Alyssa Turney is free after the judge acquitted him of all charges based upon a motion for judgment of acquittal, which basically means the prosecution didn't present any evidence that a reasonable juror could conclude that the defendant was guilty. So the guy that's been released is Michael Turney. This guy's 75 years old. Needless to say, he was a little bit relieved, and the family members were shocked when the judge gave the ruling. Now, this ruling came down yesterday, just a week after testimony was provided to the court. Now, Turney was on trial for second-degree murder charges in the presumed death of his stepdaughter, who vanished back in May of 2001 after she reportedly left a note that she was running away to California. Now, Alyssa has never been found. Now, prosecutors argued that Turney and Alyssa had a turbulent relationship and that he had hundreds of surveillance tapes of her to control her life. But the defense pushed back, saying there's no evidence that, well, frankly, she's even dead. And after the prosecution rested their case, the judge granted the motion to dismiss, the motion for judgment of acquittal, after attorneys cited Rule 20, which allows the court to issue an order of acquittal if there is no substantial evidence to warrant a conviction. That means it has to be a very weak case. That's weak when you have no body, unless you have somebody to explain why you're never going to find the body. Now, the defense had asked the judge to issue the acquittal based upon the lack of evidence, claiming that there was sufficient evidence that Alyssa ran away or proof that she was even dead. And the defense has argued that there isn't any DNA or blood evidence that proves Turney killed Alyssa. They also pointed out that without the body, there's no definitive proof that Alyssa isn't still alive. Like I said, Alyssa was last seen back in May of 2001 at her Phoenix home on the last day of her junior year at Paradise Valley High School. She had told her boyfriend at school that her stepfather was picking her up for lunch. Michael Turney reported her missing, but told authorities that she left a note saying that she was running away to California. In 2008, investigators re-interviewed witnesses and ended up serving a search warrant on Turney's residence. That search led to the discovery of more than 24 unregistered pipe bombs belonging to Turney. He pled guilty and served time for those crimes and was released back in 2017. Well, Alyssa's sister, Sarah, has tried to keep attention on this case through social media and her podcast called Voice for Justice. Well, she testified against her own father last week and told the court how he allegedly brainwashed her into thinking that Alyssa was a rebellious teenager who ran away to California. Sarah testified that she grew suspicious of her own father and that his renditions of what happened that day changed every time, and it led her to begin her own search for answers. When she met up with her father back in 2017 and pushed him for an explanation, he allegedly wouldn't give it to her. But he then allegedly said, to his daughter that he would tell me on his deathbed, adding that he allegedly said that he would confess to everything if the state agreed to give him a lethal injection within 10 days. I don't know. Needless to say, judges rarely ever grant a motion for a judgment of acquittal on a homicide case, ever, when there's some evidence. But the fact that they couldn't prove that the young girl, Alyssa, was actually gone, dead, deceased, tough case. And now guess what? It's done. It's over. It's not going to happen again. It's over. You got to be smart, prosecutors. You got to be smart. Don't do it because of public pressure. Don't do it because of family pressure. Only do it when you can prove your case. Hey, guess what? There's apparently another serial killer running loose. Well, not really running loose anymore, but this guy's in Oregon. So a man is a suspect in a killing of 4 to 6 women who were found dead earlier this year in the greater Portland metropolitan area. Now, several people familiar with this investigation are reporting that detectives have linked 4 of the deaths to a guy by the name of Jesse Lee Calhoun, who had a recent address in Portland. Now, obviously, serial killers are a little unusual, but according to people familiar with the case as it relates to Calhoun, he may in fact be one. Now, Calhoun is among more than 1,000 inmates who former Governor Kate Brown granted clemency, allowing them to leave prison early. Of those Brown released early, officials believe Calhoun is one whose clemency has since been revoked. Records show that Calhoun is in custody at the Snake River Correctional Institution in Ontario, Oregon, where he was lodged July 6th on charges unrelated to the murders. The charges he's being held on show up online simply as parole violations. He has not yet been charged with any of the women's deaths, although it's anticipated that will come soon. Now, back in November of 2019, when Calhoun pled guilty in separate cases to several felonies, including burglary, unauthorized possession of a stolen vehicle, and injuring a police officer and a police dog when they attempted to arrest him. Nice guy. Well, those convictions earned Mr. Calhoun 4 concurrent sentences, which means they all run together, the longest of which was 50 months, which includes the nearly 9 months he'd already served. His projected release date, chopped that off by 20% due to good behavior, was June 30th of 2022. That's according to the Oregon Department of Corrections. But another 11 months were shaved off after he joined a group of inmates fighting wildfires. He was released on July 22nd, 2021. Now, during the pandemic, Governor Brown began a process of granting mass commutations, early releases to prisoners who were well behaved, nearing the end of their sentences and particularly vulnerable to COVID-19. So in Oregon, the governor has apparently broad latitude to either release prisoners early, that's called conditional clemency, or to actually pardon them outright, which entails both releasing them and scrubbing their criminal records clean. Governor Brown made wide use of the governor's clemency powers, far more than any of her predecessors, and she shortened the sentence of 912 inmates at risk of contacting COVID, granting 130 pardons, cleared death row, and wiped away any cannabis possession convictions of nearly 50,000 people. Well, nearly 2 years later, on June of 2023, 6 bodies of young women. Kristen Smith was found on February 19th in southeast Portland. Joanna Speaks, found April 11th in Ridgefield, Washington. Charity Perry, found on April 24th at the Ainsworth State Park in eastern Multnomah County. An unidentified woman also found on April 24th in Lentz. And although the Portland Police Bureau said it did not suspect foul play, Bridget Webster, found April 30th in Polk County, and Ashley Reel, found May 7th in Clackamas County. Many people raised questions about whether these 6 deaths were actually linked. Then on June 4th, the Portland Police Bureau stated that in response to the widespread speculation that Portland Police Bureau has no reason to believe that these 6 cases are in fact connected. It's unclear whether the Police Bureau deliberately withholds information or if they knew the information has emerged since then. I mean, can you imagine the government lying to us? Oh, who would have think of such a thing? Anyway, on June 6, however, it was reported that 3 of the victims shared similar circumstances and had frequented the same place in the months before their deaths. That story did not say whether the police had a suspect. Then in the wake of these deaths, it's been learned that officials contacted Governor Tina Kotek's office about Calhoun. As Brown's successor, Kotek has the authority to end any of the conditional commutations. Kotek did so in Calhoun's case, leading to his arrest. The governor's office received a request to revoke Jesse Lee Calhoun's commutation status from the Multnomah County District Attorney's Office on July 3rd, and they fulfilled that request the same day. It's almost like they thought they had the same guy. Wow. And of course, the police had no further comment, nor did the governor's office. Then on June 6, officers from the agency, including the multiple counties, sheriffs, U.S. Marshals, moved to arrest Calhoun on a parole violation, and that's where he remains in custody. We'll see if we have another serial killer. We got kind of like a West Coast, East Coast thing. This is kind of like the West Coast, East Coast rappers. Who can do it better, I guess? We'll see. All right. Another person in a position of authority in trouble for you know what. That's right. Please meet James Silverton, the former commissioner and fire chief of the Lauderdale-by-the-Sea, Florida department. He has also worked as a volunteer Santa Claus, where he's entrusted by parents who bring their children to sit on and to lap and talk to Santa Claus during the holiday season. Yeah, that's the guy. Guess what? He now faces 10 counts of transmission of images involving children sent over electronic devices. Let your imagination run free there. Imagine what it could possibly be. Anyway, detectives in April began investigating a computer user who downloaded these images of inappropriate photographs of children. And when they seized that computer, they claimed to have discovered more than 217 files of images and videos showing various abusive type material. There were also 39 other images of videos involving other explicit depictions. What that boils down to is about 1,500 images of inappropriate children pictures. What do I keep telling you, ladies and gentlemen? They go to where the children are, and they are oftentimes in a position of authority. So no one would ever dare question them. How dare they? I've seen it. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. And finally today, our dumb criminal of the day. Please meet Anastasia Kretcher and Alexander Dillman. Now, Kretcher and Dillman were arrested after lifeguards reported seeing them engaging in sex in front of families and other beachgoers Monday afternoon in Daytona Beach. One of the lifeguards reported that Kretcher and Dillman had engaged in intercourse for approximately 15 minutes. I'm sure that lifeguard started his clock by it. Needless to say, Kretcher and Dillman left the beach after being contacted by a lifeguard. The pair was then busted after the sheriff deputies encountered them at the top of a nearby stairwell, completely naked. Now, while Kretcher denied having sex on the sand, she did say that they left the beach to find somewhere a little more private. Now, both Kretcher and Dillman were charged with indecent exposure, a misdemeanor, and booked into the county jail, where they remain behind bars. Now, Mr. Dillman was also charged with resisting arrest for allegedly refusing to get into the squad car. probably because he didn't have his pants on. Anyway, Crutcher is facing an aggravated battery count for an earlier incident Monday during which he allegedly struck a female acquaintance with a metal beach umbrella tube. That victim told police that Crutcher, who is known as Molly, had acted belligerent and exposed herself to beachgoers all day long. What can you say, ladies and gentlemen? What can you say? Anyway, those two are our dumb criminals of the day. I get it. There's something romantic about a beach. A little less romantic when there's a whole lot of people out there standing around watching you. I wonder how many phones were broken out with people recording it. Anyway, that's all we have for you today. Hope you enjoyed the show. Please remember to join us live, and we'll probably do our call-in number as well. So if you have any questions, we can do that as well. So thanks for watching. We will see you next time on Crime Talk.